Hi, so good afternoon everyone. We had done the Patents Act till a certain number, till section 19. Today we'll be going ahead beyond that, that is section 20 onwards. Okay, so I've prepared these entire notes. It takes hours and hours of efforts to make these PPT slides. Okay, so I have made it so it becomes very simple for you, although in a short time we cover more number of content. Now before I start, I just need a confirmation whether I'm audible and visible or to you all, so we can quickly start with the lecture. Okay, great. So I just need a confirmation whether I'm audible and visible, and we start and complete this particular topic. Okay, so first of all, thank you so much for your patience. It just takes time to make this entire PPT slides. Okay, so we will begin. Now, we had done yesterday till section 19. Today we'll be doing section 19 onwards, that's section 20. Okay, so you can keep your modules of the new syllabus open and you can complete it with me as well. Okay, now let's begin. So now after section 19, the part that we will be starting is your section number 20. Now, section 20 is basically telling, when I read out the section, you might possibly not understand anything about it. Okay, so let me first read it out to you. Okay, and then I will explain it to you. So this is section number 20, which talks about substitution of the applicant. Now, what do you understand by the word substitution? Substitution means to change, to come in place of the person. Okay, just a second. Okay, now that we have done section number 19, now we will start section number 20. Now section number 20 is basically, if you just read it up, you might not understand anything. Okay, so I will explain it to you. First I will read it out to you and let's see if you can understand and how much you can understand. So section number 20 talks about substitution of applicants. Now substitution means to change, to come in place of. So imagine there is an applicant and I am making an application to the controller that instead of this applicant, make me the applicant. So I want him to be replaced. Very simple. That's called as substitution of application. If the controller is satisfied, controller of patents is satisfied, feels that it is genuine on a claim, okay, received any time before a patent has been granted, before the grant of patent. So the application is pending, patent is pending, and someone has applied that, listen, please change the applicant's name and put my name in his place. By virtue of an agreement. So now the person is saying, by filing an application, that by virtue of an assignment, sale, or an agreement in writing, okay, made by the applicant or one or more of the applicants, that or by operation of law, that the claimant would, if the patent were granted, be entitled thereto or have interest or an undivided interest in the particular patent. Then the controller may direct that the application shall be proceeded in the name of the claimant and in the name of the claimants, as the case may be. Now what does this entire thing mean? It sounds very, very complicated, but it is not. So let me explain what kind of scenarios are covered. Let's say if there is a case of mergers and amalgamation. Let's say that the merger company, okay, there is company A and company B that have got merged into company AB. Now what is happening is, company A must have a application pending, and company B, they both are getting merged and they're going to have a application AB, new company called as company AB. Now a patent pending application was given under the company A name, and in between all this, till patent granting takes time, in that the company got merged. So now what will happen? So then company A will file a application under section 20 that, listen, the original applicant is company A, but by virtue of a merger agreement, I am entitled to the patent now. And if company A is also agreeing, then this name will come, the applicant's name will be substituted and the new name will come in. Let's take another example. If there is a person, okay, he made an application for grant of patent and the patent is pending. Grant of patent is pending. In between, he dies. Unfortunate, there is a death. So now obviously the patent can't be granted in the name of a deceased person in place of a non-living person. Then what will happen? The controller will grant, first of all, the legal heirs, whoever is the legal heir, legal claimant, okay, successor, will make an application to the controller that listen, application was filed by them, but now I am the entitled claimant. One, we saw this was due to an agreement, okay, this was entered between an agreement between the parties. So that is why you missed company AB got the claim. Here this is by operation of law. Operation of law means by virtue of law, there was no action by this party, there was no agreement, the inventor died, so automatically by operation of law the legal heirs will now become the entitled claimants. Okay, or another example is, one more example if you want to see, is a dispute resolution. For example, there was a court case going on and the application was pending and one party won the case. Then they will apply to the controller that listen, that person lost the name, please remove his name and put my name in his place. So on pursuant to a court order also this can be done. So let's see what does section 20 cover, what all scenarios do they cover. So section 20 is about substituting, changing the applicant's name or changing the applicant. This is filed in form number 6 and it is for change of name of the applicant by virtue of an assignment or an agreement in writing. We saw mergers or sale agreement also. We can say that I have sold my invention to someone else. I had made the application, it was pending, and in between I sold it to someone else. So by way of an assignment, by way of a sale, that person will now be entitled to the invention in his name because the original inventor has assigned it or sold it to him. Okay. And the third is by death. We saw operation of law. And if the controller is satisfied, he will put the name of the claimant in the application. So we saw what are the conditions. First is it should be before the grant of patent. So section 20 applies when this is before the grant of patent. Moment the patent is granted, then this section will not apply. Okay. And here what is happening, the applicant is saying that please substitute the name of the original applicant, or it could happen that they could tell that add my name also. So let's say company A is getting merged with company B. So company B can also come in and say that listen, by virtue of an agreement, we both are going to be there. Or let's take another example where I have sold off my rights. Now this was a very classic case. So what happened is I can sell my rights. Okay, as an inventor, I can sell my rights. I can sell it in India. I can sell it out of India. So as I have assigned my rights which works out of India to someone else, and in India I have kept it with myself. So we will see that also can be done. So whatever assignment you want to do could be a complete part. It is up to you. You are the owner. So if that kind is there, so then there will be joint owners. That also can be done. Or by way of a court case, we came to know that both the brothers are entitled to this particular invention. That can also be there. There are co-founders now. So that also is possible. So this can happen due to assignment, that is deed of assignment, sale, operation of law. Operation of law could be insolvency, or by court case, I have won the case. Okay. So let's say I had put my invention as on stake to get a loan. Could not repay the loan. Now the bank will take the invention in their name. That can also be done. Death or a dispute between the applicants. Okay, so now if you read it, you will find it very simple if you keep the situations in mind. Section 20 says that if the controller is satisfied on a claim made at any time before the grant of patent by virtue of an assignment or an agreement or by operation of law. So 3 cases they have given: assignment, in writing, or by operation of law. That what is he saying? The person is saying that he is entitled, he is the claimant, would be entitled to the patent granted or interest therein, or get complete interest share in the patents or part. Then the controller may direct and to correct the name in the application, whether it be in joint or in sole. Now consent required. Now I told you, whenever it is there, we are going to add one. Let's say there are 2 joint owners and we want to add a 3rd joint owner, or there is one, you want to add one more. So when you can't just add it, you require consent of the others also, unless there is a court case. No such direction shall, however, be given by virtue of an agreement or assignment. See, whenever we say that it is due to an agreement and an assignment, operation of law is different, by court order or death, that is different. So we are covering that whenever we are saying that there is an agreement or an assignment by which you are claiming to become the owner, then consent of everyone is required. It will not be allowed unless consent of the other applicants is, all the applicants is also taken. Simple, logical, yes. Now let's see, some conditions are to be fulfilled. First, no such direction shall be given. The controller shall not give any such direction by virtue of any assignment or agreement, unless, now let's understand what is happening is, there is a claimant, he is coming and saying that I am entitled to this invention by virtue of this sale agreement, this joint venture agreement, this merger agreement. So the controller shall not give unless the invention has been properly identified with the reference number. This is very obvious. So which invention are we talking about in which you want to be the claimant? That has to be given. That name has to be given. Obviously, okay. So basic thing they have given. Second, it should be made with the consent or an acknowledgement that it relates to the invention. The original applicant should say that, listen, there is an agreement. There is an agreement. He has to acknowledge that agreement. So consent of everyone is coming only, right? So consent is also coming. What is happening that there is produced to the controller. To the controller, we have to produce an acknowledgement by the person by whom the assignment or agreement was made. So if I am the original inventor, I had assigned it. So my acknowledgement has to be there. The agreement copy has to be given that the assignment relates to the invention. So when I am acknowledging also, I am telling that this is the invention number on which I have sold, or which his name also should be added. Third, it is rights of the claimants have been established by a decision of the court. So court case was filed, dispute between 2 founders, and court said that let's split the owners, both the parties are entitled. So that can also be done. And the controller gives the directions for enabling the application to proceed. And the controller gives the directions for enabling the application to proceed, for allowing the application to proceed. So what all conditions are there? Let's see. Can you remember any of the conditions? Okay. So there are total 4 conditions given. 4 conditions given. First one is consent of all the joint applicants should be there. If we are saying there's an agreement, assignment, so consent is required. Second, okay. Second, it refers to the patent application by number. We saw that it should be clearly mentioning that this is the invention number that we are talking about. Next, acknowledged by the application to be related. Acknowledged by the applicant that it relates to this invention. Acknowledgement should be there that yes, the original person should acknowledge the agreement, should acknowledge the assignment, and it should say that this is with respect to this particular invention by reference number. Very simple, very easy, and or if it is ordered by a decision of court. So then the controller will then proceed to do this. Now we are talking of death. We saw all these cases, but we never saw about in case of death what will happen. Okay, so let's say if a person, okay, dies, then obviously his legal representatives will either come by a probate, that is a will, or recognized by court, is called as a probate. An order of court stating that the will is valid is called as a probate. One. Second, maybe you have a nomination form that was made. So whatever legal heirship certificate, succession certificate, whatever it is, the controller will tell that how will I know that you are his child, and how will I know that you are the only child, or there are more children. So please go to the court, get an order from the court that these are the legal heirs. So in that case, for the legal heirship certificate, the person will have to go to the high court, will have to give his family tree, will have to give a newspaper advertisement, or indemnity bond that if anybody arises tomorrow, I will indemnify. So then the controller will say, get an order of court with respect to all this, then I will give. Okay. So again, very simple when you're talking of death of the applicant. When one of the two, now what are they, which situation they're giving? When one of two or more applicant dies. So we are talking of joint ownership, out of which one dies. The controller may, upon the request of the survivors and with the consent of the legal representatives of the deceased, direct that the application shall be proceeded in the name of the survivor or survivors alone. Okay, so it is possible that there might be an agreement between the legal heirs and the other joint holders that whether they are being bought out or their name should be added. So whatever it is, the controller will very simple ask the consent of everyone. Now obviously it is possible that there is a dispute. Then the controller may, upon hearing all the parties and the decision of the court, pass an order as he deems fit. Super simple, very, very easy. Now we are seeing section number 21. Now what does section number 21 says? Time for... Now we are talking of section number 21, time for putting the application in order for a grant. Time for putting application in order for grant. What does it mean? See, very simple, that if you want your application to be, your patent to be granted, your application to be approved, you also have to do some formalities, yes or no? What will be the formality? That whenever they have asked for any documents, you have produced it, all the legal timelines you should have fulfilled, then only the application will be granted and the patent will come in your name. Otherwise it will be treated abandoned. Otherwise it will be treated, you file the application and did not do anything to get the application, the patent granted, so it will be treated as abandoned, left, not interested anymore. So let's read what they've given. Complete the formalities within the time limit. That's the most logical thing that we will say in section 21, that listen, there are a lot of timelines that you have to complete. An application for patent shall be deemed to have been abandoned. Okay, so it's a very strong statement that we are saying that the application is deemed to be abandoned, left, not interested, unless the applicant has complied with all the requirements imposed under him under the act, with respect to any details, with reference to any controller's demands, etc. Now we are talking of patent cooperation treaty. Similar points where now in the subsection 1 they have given you an explanation. What does it say? An applicant filed under the patent cooperation treaty designating India, any document filed as a part of the application has been returned to the applicant by the controller. Any document filed has been returned to the applicant by the controller. So what is happening is, an international patent is being filed by someone and they are asking for some kind of protection, and it's an application stage. The controller can ask for certain additional demands. Okay, so any document filed as a part of the application has been returned by the controller. So controller has said, this document, you take it back, correct it, make the changes and give it back to me. And the applicant shall not be deemed to have complied with such requirements unless you have refiled it or proved to the satisfaction that it is beyond his control. Such document could not be refiled. Very simple. In the patent cooperation treaty, the controller has given back some document saying that get this back again. If you have not refiled, or if you said that why you can't refile to my satisfaction, then it is fine. Otherwise, we will treat it abandoned again. Very, very simple. That comply with all the timelines as well as demands of controller. Time extended if case is pending in court. Now what happens is, there are timelines in law, but if you have, there is a matter pending in the High Court, so obviously it cannot be treated as abandoned because the matter is pending in court. If at the expiration of the period an appeal to the High Court is pending, so time is over and appeal is pending, so will we treat it as abandoned? Answer is no. We shall extend the timeline until such the date as the High Court may determine. Or a case of patent of addition, we will see in the next section, an appeal is pending. The time within which the requirements of controller shall be complied shall be extended. Very, very simple. If there is a court case, the time period will be extended till the High Court has disposed of the matter. Now we are seeing patent opposition in India. Till now, what was happening is, you had given an application for grant of patent. Okay. Now you have made an application, the controller asks for information, then he will later make a publication. Okay, we also saw that he will make a publication. Once he makes a publication in the patent journal, there is a possibility that there is an opposition that might come. Someone might contest it. So you have your section 25 dealing with patent opposition in India. Now, before the grant of patent, if someone makes an objection, it is in section 25 subsection 1. That means in the application stage only someone is creating an objection. Listen, that don't grant him the patent. This is my invention. It is priorly published. It is not inventable. It is not under section 3. Any of the thing, he is not disclosed all the facts. Priority date is mine. So even before the grant of patent, if the objection is made, it is all covered under section 25 subsection 1. 25 subsection 2 talks about post grant opposition. What do you mean by post grant opposition? Means patent has been granted. Later this opposer or whatever, this disputer woke up and he said, oh my god, patent has already been granted, I want to file an objection. So those scenarios are covered under section 25 subsection 2. Let's see each of them and close it. Section 25 subsection 1 talks about pre-grant opposition of patents. What does it say? Here, can you tell me, is the patent granted? Is the patent granted? Answer is no. Okay. Section 25 subsection 1 provides that where an application for a patent has been published, so what has happened is, application has been published and the patent has not yet been granted. Any person may oppose to the controller against the grant of patent on the following grounds. So we will see, there have been given you grounds on which oppositions can be made. The controller on request of such person shall hear him and dispose of the representation in the manner specified. The controller, on request of such person, hear him and then dispose of the matter as he prescribed. Now, what are the reasons for opposing the patent? Can you think and tell me? I want you to think and tell. And if you go to see, the grounds for pre-opposition and post-opposition is almost the same. So your one stone, with one stone you will kill two birds. So let's see, all the conditions are important. First is the applicant can say that this person has wrongfully obtained the invention. So we can say that the applicant has wrongly obtained the invention. He must have hacked my email ID and obtained it, etc. So that can as a proper ground for opposing the patent. Second, the invention has been published before the priority date. Let's say, remember that when we file provisional patent, we file it and get a priority date. But if someone proves that even before this date, it was already published, so then obviously that grant of patent will not be there because it's already prior knowledge. Next, okay, the invention so far claimed in any of the complete is claimed in a complete specification published. Okay, so the invention that you're claiming is already claimed in another publication after the priority date of this person. Being a claim on which the priority date is earlier than the applicant's priority date. So as I told you, the priority date, someone else has already filed and it is way before you. So the priority date of the applicant is unfortunately later than that of another inventor, and that could be a ground for opposing the patent. Okay, it was publicly known. Okay, the invention was publicly known before the priority date claimed by him. The invention so far claimed in any of the claim of the complete specification is obvious, clear, and does not involve inventive step. So you can say it's a very obvious invention. It is not clearly given and it does not involve a inventive step. So I hope you're taking notes, because once the grounds are over, I'll ask you how much you can remember. Subject to any claim of complete specification is not an invention. So it is not an invention. That could be another ground. It does not sufficiently describe the invention. So it does not describe the invention. That the applicant has failed to disclose to the controller the information required. So whatever information the controller has asked has not been provided. Does not describe the invention. It has failed to disclose to the controller the information required. Next, that the applicant was, remember, in case of convention applications, that is international applications, it has to be filed within 12 months from the claim that they've got in their home country. But if it is not there within 12 months, then it is a ground for opposing the grant of patent. The application was not made within 12 months from the date of the first application for protection of invention made in the convention country. So if, let's say, USA is a convention country, if it has been published in USA, granted in USA, within 12 months you have to apply for international grant of patent. If you don't do that, you won't get protected. The complete specification does not disclose the source of the geographical origin of the biological material. Again, we had seen that if there is, with respect to some biological material, that sample copy has to be given, where that sample copy can be inspected has to be given. So the sample has to be kept in a location. All of that has to be there, and we've seen it was as per the Budapest Convention. That so far claimed in any claim of the convention specification is anticipated having regard to the knowledge available within any locality, indigenous community in India or elsewhere. Again, we are saying that it is already anticipated by the knowledge of XYZ community. So if a particular community is from many years using a particular thing, knowledge is already available, and from that you've got and you want to patent it, it will not be allowed. So there are a lot of points from here. Can you tell me how many do you remember? So they have given you till K. Okay. So let's see, let's do a recap, and now I want, after I have read, you should be able to tell. So let's see, it's a most important question of examiner. First, grounds for opposition of patent. Let's see. The grounds for opposition of patent are covered under section 25. The grounds have been summarized below. First one, invention is wrongfully obtained. Second, it has been published before the priority date. Third, someone has made a prior claim. Next, it is publicly known or publicly used. It is obvious and lacks inventive step. It is not an invention or not patentable. Next, it is not sufficiently been described. Non-disclosure of information, so they have given that certain information was asked, etc., is not been disclosed. Time barred application, so in case of convention countries, within 12 months the application was not filed. The geographical territory of the biological material has not been stated. Invention anticipated by any local community, indigenous community, whether in India or outside India, could be a ground for opposing the patent. Very, very simple. These were all the grounds for opposing patents before the grant of patent. However, if you go to see, the grounds for post-grant opposition is also the same. Okay, but it is given under section 25 subsection 2. Section 25 subsection 2 entitles any interested person to give an opposition to the controller after the grant of the patent, but before the expiry of 1 year from the date of publication of the grant of patent. So very, very simple. Can you oppose a patent which has been granted and 2 years have lapsed? Answer is no. So if you want to object, you have 1 year time from the date of grant of patent. So mark it as important that even after the grant of patent you are allowed to oppose, provided that the application is made within 1 year from the grant of the patent, and only on the following grounds. Again, the grounds are absolutely same, replica. So wrongfully obtained was there. Prior, it has been published priorly, also there. It is in priority claim of someone else. Another person has already have a earlier priority date. It was invention was publicly known or publicly used in India before the priority date. Everybody was using the product. Okay, now it is to be noted that an invention relating to a process for which a patent has been granted is deemed to have been publicly known if the product made by the process has already been imported into India before the date. See, publicly known, they have given you 1 point for publicly known. What are they saying? That if there is an import of the product and it is being used, so again it means it is publicly known. However, they have given an exception which is important. What is the exception? Where such importation has been used for the purpose of reasonable trial or experiment only. Except where such importation, means the product was imported, so we believe that it is priorly published, but there is an exception, except where such importation has been done for the purpose of trial and experiment only. So it is to be noted that an invention relating to a process for which a patent is granted has been deemed to have been publicly known if the product made by that process had already been imported into India before that date. So let's say there is a product, you have made a process which makes that product. Now this product has already been made abroad and it has already been imported from abroad. So you will not be granted, except where the importation is for the purpose of trials and experiments only. Okay, so it's not being commercially used. Next, that the invention is obvious and does not involve inventive step. It is not an invention within the meaning of the act, does not sufficiently disclose the invention, is failed to disclose to the controller the relevant information required. In case of convention application, it is not made within 12 months. The geographical origin of the biological material is not being given and the source. it has been anticipated in the knowledge within a local territory. Same point. So we did the grounds 3 times. Okay, and section 25. Now we are seeing section 25 subsection 3. Now we are seeing section 25 subsection 3. It says opposition of board and its proceedings. Opposition of board and its proceedings. Opposition board. Now what does it mean? You think the controller will conduct inquiries? He himself will go and do, or he will have to hire a agency and tell the agency, do the investigation, prepare the report and give me. So whenever there is an objections, whenever there is this objection under section 25 subsection 1 and 2, okay, where any such notice is duly given under subsection 2, the controller shall notify the patentee and constitute a board. So in subsection 2, when this is there, the controller shall notify the patentee. So we will have to tell the patentee, listen, your patented invention has been objected. And we will constitute a opposition board. The name of the board is opposition board. Okay, consisting of such officers as may be defined, and refer the notice of opposition along with the documents to the opposition board for examination and submission of its recommendation. Every opposition board is required to conduct the examination in accordance with the prescribed procedure. Next, section 25 subsection 4, controller passes the order. Once you have this opposition board, it will investigate and you will pass the order. The controller shall, on receipt of the recommendation of the opposition board and after giving the opponent the opportunity of being heard, pass an order as it may deem fit, whether to revoke or amend or maintain the patent. Whether to maintain it, that is keep it, whether to tell them to change, or whether to cancel it completely. Now imagine you have this this board, opposition board, there will be controller, etc. You think the controller can keep closed room trials, secret trials, not inform anyone of what is going on? Because normally in any court case, the judge is not sitting alone with the party. You have the other side also, and then there are arguments. So no secret trial can be done. Okay, because it will lead to corruption and independence will be lost. The controller, while passing the order, shall not take into account any personal document. So there are sometimes envelopes have been given, closed envelopes. That is not allowed. Secret trials, secret use in case opposition should not be allowed. Order of controller, patent stands amended. So whatever on hearing of all the parties, the controller passed the order, that shall be final, and that the patent shall stand amended accordingly. Means as the order is there, the patent will stand amended accordingly. Next, we are seeing controller to treat application as application of opponent. See, controller to treat application as application of opponent means what? Means the controller, there is an applicant, okay, original applicant, and there they came as an opposition came, and there was an opponent who came and said that invention is mine. Now what happened is, the applicant gave this application for patent, application for grant of patents. Later it was found that the opponent won the court case, won the the entire dispute, arguments were in favor, the order was passed in favor of the opponent. So automatically controller will now just treat, is possible on request, that he will say this application of patent can be said that it is that of the opponent. So they just substitute the names. So this is only if the controller, the opponent has won the case. So let's read the provisions. Section 26 of the Act provides that where in opposition of the proceedings, the controller finds that the invention so far claimed in any claim was obtained from the opponent, provides that in any opposition proceedings, in any proceedings of opposition, the controller finds that the invention claimed was obtained from the opponent. For example, there was a case of Mark Zuckerberg versus another person. It went in court, and if the court found that yes, this knowledge, this entire details and invention was actually obtained from the opponent and you did wrong, so then we will say then he may direct that the patent shall stand amended in the name of the opponent. Okay, and he may pass an order that the specification be amended as he feels deemed fit. Then coming to the next thing, foreign filing permit. Now see, normally under the act they are saying that residents should not file a foreign patent application outside India unless 6 weeks have lapsed from a earlier filed Indian application for the same invention and no secrecy invention has been given under section 35, or a permit has been received from the controller prior to the filing of the foreign patent application. Now what does this mean? What does this line mean? Can you read and tell me? Resident not to file a foreign patent application. So very simple, we are telling residents, Indian residents, that listen, don't file foreign patent applications unless 6 weeks have been over from an earlier filed Indian application for the same invention. That means Indian application is filed. Okay, Indian application has been filed and 6 weeks are over, then you are allowed to file a foreign permit. Then you can get an international patent. Then apply for that. Second, so we are taking 6 weeks time. Indian government is saying 6 weeks time. Or if the controller is given prior to filing this, they have given you a permission already, then you can go. So remember 6 weeks is there. Then we will say, okay, fine, you can file a foreign filing permit. Once you do that, the publication will be done abroad India, outside India also, and the name will be granted. So this kind of patent which you are applying for international patents also will be allowed if there is no secrecy direction under section 35. We have done section 35 where the central government feels that it is important that this invention not be disclosed because the sovereignty, integrity, security of India is there, or the defense of India is involved, then they will give. So very simple, it should not be should not fall under section 35. 6 weeks should lapse from the Indian application date, then you can make a foreign filing. Let's read it up and understand. So residents not to apply for patents outside India without the prior permission of the Indian government. Section 39, so whenever we file international applications, it is with the consent of the government. The portal is made in such a way. Everything can be done online also. Section 39 of the Act provides that no person resident in India shall, except under the authority of a written permit sought in the prescribed manner of the controller. So you require a written permit, okay, of the controller, shall make any application outside India for grant of the patent, unless an application for the patent for the same invention has been made in India and not less than 6 weeks have lapsed before the application outside India, and that no direction under section 35 has been given. Okay, so no person resident in India shall, except with the consent of this, make a foreign application, apply the patents outside India, unless a application for patent for the same invention has been made in India. So obviously you can't directly make a foreign filing application when you have not filed in India only. So that application for patent for the same invention has to be done in India, and cooling period is there, that is 6 weeks. Second, obliges the controller to dispose of every application So they have given a time period, the controller has to adhere to that. However, if the invention is relevant for the defense of India, the controller shall not grant the permission without the prior consent of central government. So if we feel that it is with respect to defense of India, then he shall not do except with the consent of central government. Okay. Now, my question is, does this section only apply to residents or even foreigners? Clearly they have said residents. So here the third point is also saying that section 39 shall not apply in relation to an invention which an application for protection has first been made a country outside India by a person resident outside India. Now imagine if the application has first been made outside India by a person resident outside India, this section will not apply only. It is in applying where an Indian has applied in India for a patent. Once 6 weeks have lapsed, then he can apply for foreign international patents also. So it applies to them. But it will not apply to a foreigner who has applied in his home country and then is applying. So that is not there only. Common sense, because this is only for residents. Now coming to patent pending, now granted. Normally it might take 4 to 5 years for a patent to be granted. Now they are trying to expedite it and try to give the patent, but you will have to pay a little hefty sum to get the patent granted within 1 year. That can also be done. Okay, now the grant of patent. First, the patent should be granted as soon as possible. Once the patent has been granted, you will get a stamp, a seal of the patent ministry that the patent is in your name. You will get a certificate. Your name will come up in the registry as well with the application number that you are the inventor. Grant of patent. Market is important. Section 43, okay, dealing with the grants of patents, provides that where an application for patent has been found to be in order, everything is in place, okay, and the application has not been refused and the application is not in contravention of the law, then obviously the patent should be granted as expeditiously as possible. As soon as possible it should be granted, and that too with the seal of the patent office. Okay, and the date on which the patent is granted is to be entered in the register. The controller shall make a publication and this shall be open for inspection. So today any of us can find out who is the inventor of any particular invention. You have to go to the registry and it's open for public inspection as well. Now coming the terms and conditions of the patent. Now when they grant the patent to you, you are extremely happy. You said I went through the entire application stage, then the opposition stage, and then I got the granting of patents, and you become very, very happy, and then you get a seal that patent registered, patented. Then the government puts this, something like this. What is this? Normally when we go to buy any product or we see any advertisement, what is this? Terms and conditions apply. So saying, wait, what terms and conditions? So if I am the inventor, I'm wondering what are the terms and conditions for grant of patent? So they are saying this is the conditions for grant of patent. Section 47 covers the conditions for grant of patent. Very simple, that if the government wants, they can take your product. If any kind of medical hospital etc. wants a government hospital, we can take your product. Okay, we may or may not give you some fees, that is a different thing, but we have a right to use your product, the government. So let's see. So this your monopoly right is because we've already given you a monopoly right subject to terms and conditions. So it is very rare that the government might forcefully take your product for using it in a specified period, but they can do that. Let's read this. The section 47 dealing with grant of patents, that and if you don't want, then don't do it. If you don't want us to take it in when we feel necessary, then don't come only. So this is very rare cases that the government might come to take your product. Section 47 provides that the grant of patent shall be subject to the conditions that any machine, now we are talking of goods, we are talking of any goods, machines, etc. So we know product patent can be there and process patent can be there. Okay. So now we are talking of product. So any machine, apparatus, device, gadget or other article for which patent has been granted may be used or made or on behalf of the government for the purpose merely for its own use. So what are they said that if the government wants, they can take it. Second, product patent is also there and even process patent. So even if someone has a process, same points. If there is a process for which the patent has been granted, may be used by the government merely for its own use. I say okay, fine. The government will be used. The government can use it, fine. Very rarely, government will come and try to take a product. Then I will say, listen, for research and research, including imparting instructions to the pupils, to the students, it may be used. So for example, a machine, like let's say there is a particular device or a medical instrument. Now if I want to use it to teach the students, if I'm a doctor and I want to use that thing which is already patented, it can be used. Okay, may be used for the purpose of experiment and research, including imparting instructions to the students. Okay, same thing, any product or process or machine or apparatus or article for which patent has been granted may be used for the purpose merely of experiment or research, including imparting instructions to the tutor. So we are not going to sell it. There is not going to be commercial outcomes. You have monopoly right on commercialization. We can do research. Government can use. In the case of a patent being a medicine or a drug, the medicine may be imported by the government. Now imported means may be used by the government for the purpose merely of its own use or distribution in any dispensary, in any hospital on behalf of the government or medical institution. So let's say there is some medicine etc. which you have got Dr. Reddy as a patent in their name. Okay, there is CIPLA might have a patent in their name. There is Sun Pharma that might have a lot of patents in their name. If the government hospital needs, they can take it. If any other medical institution, okay, medical college, they can use it. So these are the terms and conditions when we are granting you the patent. Now we are seeing the rights of the patentee. What are your rights? Very, very simple. I can bifurcate it into two rights: positive rights and negative rights. Positive rights are that you can use, you can destroy, you can assign, you can do this, you can do that, you can monopolize everything. You can put for it can be given, assignment can be done, or there is one more thing where you license it. So you can even give it for license for someone to use it for product, you might get some money, etc. Or negative right is a right to stop others from doing anything, a right to file cases, a right to stop, prevent anyone from making copy, using, doing any kind of improvements and getting it in their name. All that you will have. Let's read very simple points. Section 48 provides that a patent granted under the Act shall confer upon the patentee the exclusive right to prevent the third parties not to use a product without his consent, to make, sell, distribute, import, etc. Now this with respect to when the patent is a product. Now I told you there can be two kinds of things: product patents or process patent. If there is respect to process, then obviously process is not you can't make a process. It is about this, the words are different, concept is the same. With respect to exclusive right to prevent a third party from using it, just the languages are different but the content inside is same. What are the rights of a patentee once the patent is granted? So obviously they enjoy exclusive right to make and use the invention, assign it, grant licenses, deal in the product as they want for any consideration. Now we are seeing the other thing, the term of the patent, one of the most important parts of the chapter. Once a patent is granted, okay, we saw granted, subject to terms and conditions. Okay, fine, some terms and conditions I'll adjust. But then now my question is, am I protected for lifetime? Do I have monopoly rights for lifetime? or I can keep renewing it continuously till lifetime? So the answer is no. You have to remember that patent is granted only for 20 years from the date of patent. Now see, 20 years from when is also important. From the date of filing the invention shall be from the date of filing the application for patent. Because even in this they will ask from the time of grant of patent, from the time of filing the patent, from the time when it was published. So no, from the time of filing the patent till 20 years you have a monopoly right. After that it goes into public domain and public can now use and exploit your product. You can't do anything. So 20 years is more than enough to get a monopoly right. Date of the patent. Date of the patent, a date of application filed in India is the, in case of ordinary application, we saw it is 20 years. But 20 years from when? 20 years in case of ordinary case when the application is filed in India. But what if it is an international patent filed under the Patent Cooperation Treaty? Then again 20 years only, 20 years, but from the date of international application date in receiving office. International application date. Okay, so let's see. This is given in your section number 53. Term of the patent. Multiple times it will come in your exams. Market is important. According to section 53, the term of every patent, okay, which is not now very important. It will be 20 years unless seized earlier, unless expired earlier, unless become for any reason it has ended early. So a person has a right to surrender his patent. So then it will not there. Normal cases it will last for 20 years from the date of filing the patent. The term of the patent in case of international application shall be 20 years from the international filing date. A patent shall cease to have effect on expiration of that date of the said period, or if the fees was not paid in the prescribed period. Okay, on cessation, the payment right to due to non-payment of renewal fees, the subject matter covered by shall not be entitled to any protection. So again, they are saying that if you not make the payments, now within the 20 years also there might be renewals and extension which you might have to pay. If you don't pay, then you won't get protected. Now coming to the next thing, product improvements. Very, very important is let's say when an invention is made and patent has been granted, you think innovation will stop or it will continue to happen? Okay, you think the innovation will stop or it will continue to happen? Obviously, innovation keeps on going on a regular basis. Now what happens is, if you on your original patent, if there is two things, either a IM, a improvement or modification on original patent, on the original patent, okay, on the original patent, then what happens is you want to protect your improvement and modification also. Yes or no? You would want to protect your improvement and modification also. So you can file something called as patent of addition. Patent of addition. That please add these two features also in my original product. Okay, I have launched some new features. So that will be there. For example, let's say there is the iPhone. Okay. The iPhone is there. The entire working has been patented. Out of that, they have done some improvement into the camera quality, or they have decided that a front camera should have a flashlight which is in something, but the original patent is there. The original patent, let's say, is for the phone, and there is some upgradation, new version that has come. Now understand what happens and why this provision of patent of addition is there. First, this improvement or modification may not be by itself be registered as a patent. Just the improvement cannot be, imagine if I have made a camera and in the camera I have added one more feature, okay, of autofocus. Okay, this is one more feature into my entire camera which I have done. Now that autofocus itself is not that great an invention to be patented. So I might lose my rights and someone might try to work on that. So my the most logical sense is to tell the controller that listen, please add these features, this improvement or modification in the original patent. And then you will get protected for all, including these extra features. Okay, so this is a very good provision which is there. Now let's see the other one. Okay, like for example, just giving an example that WhatsApp was there. WhatsApp came out, was a software which was working, etc. And they came up with an improvement that listen, now the messages are going to be encrypted. So the same thing, same invention, but some kind of additions have been done, minor addition. Now these are all industry specific, product specific, but we understood that you can get a patent of addition. Now why would you get it? Because that improvement or addition might not independently be eligible for a patent. Main invention and this. So this is given that allows the inventor to obtain a patent of addition for improvement or modification of their existing inventions. Now, the first provision you read, I will ask you a question from here. Okay, let's read together, then I will ask you a question. Section 54 provides that where an application is made for a patent in respect of any improvement or modification of an invention in which the complete disclosures have been given. So obviously when you must have got the granting of the original patent, you must have given a complete specification. All the details must have been given. Here also that improvement, modification, complete details have been given. The applicant shall also apply for that invention is or is a patentee in respect thereof. The controller may, if the applicant so requests, grant the patent for improvement of this as a patent of addition. That the controller may grant the patent for improvement or modification as a patent of addition. My question for you: can anyone else other than the original inventor apply for registration of the improvement or modification? Read the provision and tell me, can someone else apply for registration of improvement or modification, okay, in the patent other than the inventor, original inventor? What do you think? Yes or no? So the answer is no. It has to be the inventor himself who has invented the product as well as invented the improvement or modification. Where it is written? So it is written that the applicant also applies. Also, that means he has filed a main application and is also applying for the improvement and modification. So the provision, just remember that it is only the original inventor can apply for improvement or modification. Now, second scenario. Now, second case. I told you the first case where the improvement or modification was minor, which otherwise would have not been patented. So you will go under subsection 1. Now subsection 2 says that the improvement or modification is substantial, significant, which the person, the inventor himself has applied for a separate patent in a separate application as an independent patent. For example, I have done product A, and now product A I have done some improvement for which I am filing an independent patent, which I believe I will be granted the independent patent also as a separate thing. So major invention has come, but it is also an extension of the original product. Now the question comes that option is given to the inventor that if he wants to merge the applications, he can do that. If he wants, see, this will take normally lot of time, it'll cost more, so you can tell that let's merge it up. Okay, so where an invention being an improvement or modification of another invention which is subject of an independent patent, means an independent patent is applied and there is another invention which is there, which is actually a improvement or modification of the original thing, and the patentee, see again, and the patentee is also the patentee in respect of that invention. Again, so a third party is not covered only. It has to be the creator who is making product A and product B, is what it is there. Then if the inventor says that listen, that was an independent application, please consider, I didn't know about patent of addition, please merge it and make it as patent of addition only. The controller may, if the patentee so request, revoke the improvement and modification, and as a separate application this will be revoked, and grant the patentee a patent of addition. A patent of addition. So, a independent application was filed to register the improvement or modification. He did not, let's say, know about it, or maybe he thought, let me have a separate thing, but then he realized, I don't want to wait, I want to go faster into this. Please treat it as an improvement or modification and merge it up. So it will not be an independent application, it will be treated as a patent of addition. So that new feature will not be registered as a separate patent, but will be registered as a patent of addition, which means that it is a original patent, few more features added. Very simple, very easy. Bearing the same date, now the date of this patent of addition will be the same date of the date the patent gets revoked. This patent application gets revoked. So let's see what is there in simple terms. If someone owns a patent for both the main invention and the improvement, they can request the controller to replace the separate improvement patent with a new one, calling it as a patent of addition. Now, date of filing, very simple and very logical also. Tell me one thing, the application for original patent will come first, application for original invention will come first, or the improvement or modification? Tell me, sequentially, which will come first? Original invention will come first, or the improvement or modification will come first? Obviously, there will be first original application for the main invention, and then subsequently have improvement and modification. So this is what is given. A patent shall not be granted for patent and addition unless the date of filing the application is same or later than the date of filing the application in respect of the main invention. That means main invention will come first and the patent of addition will come later. Logical sense. Next, grant sequence. Now obviously when the government is granting, they will grant the original invention first and then only the main invention. So the patent of addition shall not be granted before the main invention. Very, very simple, very, very easy. Next, section 55, term of the patent of addition. Now we've done patent of addition, we beautifully understood what is patent of addition. It's just adding up the new features into the main product. Now what will be, see, we know patent is protected for 20 years, right? Patent is protected for 20 years. Now the original application date might be X and the invention, the improvement and modification application will come later. So 20 years for the improvement and modification will start from when? What do you think? From the date of the original invention or from the date of getting this improvement modification? So obviously, logically, what do you think? It should be merged with the original invention, right? The date should be, and it will be deemed that it was granted at that time only, protected from that time only, and the time will lapse with the main invention, is what that is there. Let's read. Term equal to the main patent. So you get a term equal to the main patent only. There is not that for improvement, modification there will be more term. For the, it's just a feature, right? So the main invention is only there, is one and only. A patent of addition shall be granted for a term equal to the patent for the main invention unless it is expired earlier or until the predecessor of the patent for the main invention and no longer. So again, if the main invention terminates, even the improvement modification will terminate. It just kept it equal. Okay, it cannot end earlier or later, it ends equally. Thus, a patent of addition stays valid for the duration of the main patent until the main patent expires, and this will also expire. So it doesn't get a fresh validity, fresh term. Very simple and very logical also. It's just a feature which could not have been normally independently this. Now the question is renewal fees. See, no renewal fees for the patent of addition. Very, very simple. This is the main reason for filing the patent of addition. See, why am I trying to add up the features? So that it's one application, one term. So no separate fees for that. Whatever I pay for the original thing, even the extra features get covered. Because remember, we had said that it is not it could not independently be registered. But if a case is there that the patent could have been independently registered and it was an invention which we saw under the subsection, the earlier part, that it was an independent application, could have been granted if any of the patent becomes an independent patent. But if any of such patent becomes an independent patent, the same fees shall thereafter be payable upon the same dates as if the patent had been originally granted as an independent patent. So if the improvement or modification amounts to independent patent, then obviously we won't lose the filing fees. That has to be paid. Okay. Now coming, so it makes sense to register it if it's an independent, they would want to prefer it to make it separate only if it is a independent patent, because you have to as it is pay the filing fees and you would get an extension. Now section 56, validity of the patent of addition. Okay, very simple. Non-refusal, non-revocation for lack of inventive step. Now what we were seeing under these sections, the patent of addition, it would generally be applications which could not be independently patented. So these are just extensive features, some additional features, improvement, modification to the main invention. So if I am applying for patent of addition, it cannot be rejected or revoked on the ground that it did not lack inventive step or there was no massive step. I will say yes, it cannot be done. That is why I am just adding it up here. So the law has just clarified it that for patent of addition, independent innovation and all that is not required. Look it as a whole with the main invention. So the main invention is there. The main invention you have to see, is it there? Then the features also get automatically added. The features itself need not have huge amount of upgradation. The grant of patent of addition shall not be refused on the ground that the invention claimed in the complete specification does not involve any inventive step. So I will say, yeah, it's fine. You don't have to, it's just a part of it. Just add it up there. Okay, that it does not have any inventive step having regard to any publication, use of the main invention or improvement or modification of the main invention described in this of the patent of addition. So again, just remember this much, that you can't refuse a particular improvement or modification that it lacks inventive step and this. And the validity of the patent of addition shall not be questioned on the ground that the invention ought to have been subject to an independent patent. So the validity of the patent, whether it is valid, not valid, should not be questioned on the ground that the invention had to be registered independently. So we have seen that if it has been added as a patent of addition, then it is absolutely fine. Okay, you can't reject it on that ground. Because what is happening is, if you're not getting a fresh period, you're getting only that much time period, so it will be there. But if I want, then you go ahead and file a separate separate invention. If it is a separate invention, then you will get a more amount of validity period, 20 years again. So consideration of the main invention's description in assessing the novelty of the patent of addition. Now again, what they are saying is, if you don't have to look in this, you have to look it as a whole. If the main invention is new, novel, useful, non-obvious, involves inventive step, is capable of industrial usage, then that is all that is needed. Patent of addition itself need not be there. If the main invention is there, it is sufficient. The patent of addition can also be added. Let's read what they're saying. In determining the novelty, in determining that whether it is useful with respect to a patent of invention, we don't have to look at that. Look at the shall have regard to the complete specification of the main invention. So the main invention is there, it has inventive step. So we will consider that logic and apply it here also, that yes, if that is there, this is also there, and grant the patent is what they are saying. A patent of addition application cannot be rejected on the ground that it lacked inventive step. However, the disclosure in the main application can be used as evidence that this is its thing, that is why we are doing. There was a case, Ravi Kamal Bali versus Kali Tech, that dismissed that the defendant's argument that the patent of addition can only be granted if inventive step is there over the main application. So it was a case law also that it has been, this logic has been, argument has been rejected that the patent of addition can only be granted if there is inventive step. So even if the patent of addition does not involve inventive step, it is fine, it should be registered. Okay, so that is it for today. We'll be doing only this much. Tomorrow we'll cover from the restoration of lapsed patents onwards. Clear till here? Sona, good evening. Yeah, and sir, in tax law subject, our Jahangir tutorials will cover both direct and indirect taxes. Yes, obviously direct, indirect both will be covered. Clear? So that is it for today. I have covered till here. The balance part we'll do it tomorrow. Thank you so much, guys. I'll put up the lecture for tomorrow as well, and I think tomorrow mostly we should be done with this particular chapter. Take care, guys. Bye.